Can my loved one sign legal documents even with dementia? Welcome to Frank Bruno Law. I'm Frank Bruno. I'm a probate and elder law attorney in New York. The question for today is, can my loved one sign legal documents even with dementia? Let me hit you with a lawyer answer. It depends. It depends on how progressed the dementia is. And if at the time of signing, your loved one has the requisite capacity. Courts have found that even people in the most advanced stages of dementia can be competent to sign important legal documents. So the test for whether a person, including a person with Alzheimer's disease or dementia, has the ability to sign a document, and specifically for the disposition of their estate, is does the client know reasonably well what the extent of their property ownership is? So actually, it's important to understand that the medical definition of incapacity is different from the legal definition of incapacity. A person diagnosed with dementia, Alzheimer's disease, or another type of dementia, we know that there are hundreds, they may still be legally competent to sign documents. It's possible that a doctor could have already written a statement of incapacity about this person on behalf of that person, but this is not determinative of legal incapacity. The two are distinguishable. So to paraphrase, the legal test may be, does the client know reasonably well what the extent of their property is? They don't need to be exactly precise on every asset, but aware enough that we can tell that they're dealing in reality. Another question to think about as the attorney, do they know who are the natural objects of their bounty? Right? Generally, it means family, it means children. If one family member is excluded, do they know why? Another question, do they know this document gives their estate, their bounty, upon the death to the people they have named in their document? Right? Do they want to give it to an unknown person? And do these things at the time they sign these documents, they know? They may not remember 10 minutes later, but do they know whether or not at the time they signed? So the capacity requirements for each legal document can be different. So you need a little bit less of a legal capacity. And I don't like the way I said that, but the standard is higher if you are signing a contract or a deed than it is for a will. That's because the law is well settled on wills. Please speak to your estate planning attorney, or please speak to me about this if you have any questions related to any of your relatives. You can reach out to me at frankbrunolaw.com.